Republicans dead. Where I could stand in the middle of Fifth Avenue and shoot somebody and I wouldn't lose any voters, okay?
The women with the least likelihood of getting pregnant are the ones most worried about having abortions.
On January 6th of 2021, you had tens of thousands of people peacefully protesting.
So, it's not a right-wing conspiracy theory. It's not QAnon. It's real.
Joining us today on the Enemies List, we are proud to welcome Sherrilyn Ifill. Sherrilyn Ifill is an American civil rights attorney. She holds the Vernon Jordan Chair of Civil Rights at Howard University, former president director of the NAACP Legal Defense Fund, and is one of the people that understands right now the challenges to voting rights and civil rights in the country at a level that few other people do with the amount of clarity and resolution that she does. So Sherrilyn, thank you so much for joining us today, and welcome to the Enemies List.
I'm thrilled to be on.
Okay. Well, I want to start out by asking you about where you see the status of voting rights in this country right now. It is something that as a non-attorney and as just an old elections guy, I feel like that we're facing a mounting set of well-constructed, well thought out, very frankly, sort of evil challenges to voting rights in the country. And I was hoping we could get your perspective on that, because I think it's a growing and dangerous movement in the country.
Yeah, that is absolutely true. Of course, it has a very long pedigree, and it's important for people to understand that this is not a new phenomenon in American life or in American politics. And that's part of the story, because what we are seeing now is built on a platform that was created and existed for a very long time. And so the current purveyors of voter suppression and those who are, in my view, seeking quite deliberately to upend our democracy by essentially manipulating our voting and our election system, have available to them all of the arguments that were utilized in decades earlier, arguments that, at least in my view, had been discredited then and were of dubious integrity decades ago. But they have been there. They have leached into the way that judges think about election law and voting. They have been incubated in the public and among think tanks. And so the whole concept, for example, of voter fraud or ballot security has been around for, it was a tactic used by Jesse Helms and, and so it's been around for a very long time. And so the current users of this tactic have available to them all of those arguments, and they have built on them. But they are singularly more ambitious than those who came before them. And that ambition, I think, is very threatening to our democracy.
I think that's exactly right, and I mean, we see it running in, I think, parallel tracks. At the federal level, there's a very well-funded effort to basically finally sort of try to kill off the Voting Rights Act at the federal level, and at the state levels, you're seeing a lot of these sort of Jim Crow light kind of efforts to disenfranchise, particularly African American voters. What are the worst states that you can think of, and some of the worst approaches on this that you can think of that are happening out in the state levels first? Then I want to talk about the federal challenges.
Yeah. Okay. Well, so I mean, at the state level, I think the usual suspects are always available to us. So let's go alphabetically. Alabama always can be counted on. Alabama is in the process right now of engaging in defiance of federal court decisions and federal court orders, including a Supreme Court decision. And this is in the case of Milligan versus Alabama Secretary of State, where the Secretary of State, of course, is defending the redistricting scheme created by Alabama following the 2020 census. That case went all the way up to the Supreme Court. The case had been rigorously tried. Alabama lost every step of the way, and then they lost in the Supreme Court this term, something they were not expecting. But in a 5-4 decision, Justice Roberts and Justice Kavanaugh came along with the three more progressive justices to find that indeed Alabama's redistricting plan had violated Section 2 of the Voting Rights Act by failing to create an additional district that would be majority Black or that would be significantly Black in population and give Black voters an opportunity to elect or strongly influence the election of a second congressional candidate from Alabama.
Right.
The case then went back to the district court for the state to draw the district that the Supreme Court told them failing to draw had violated the Constitution. The state openly defied that, refused to do so. And there was a story in Politico about a month ago in which various members of the legislature and the Secretary of State and the Attorney General were slapping each other's backs and congratulating each other on not having what they kind of called kowtowing to the Supreme Court's decision, that they were in defiance of it. They have now been, as of this past week, very harshly rebuked by the district court. The district court is made up of a three-judge court that reviews these plans in voting rights cases, and has been very clear that they see Alabama as being in utter defiance of this federal court order. And the case is now headed back up to the Supreme Court, and Alabama is standing pat in its resistance to that redistricting. Mississippi is always, again, on the list. They are engaged in a scheme to upend the ability of voters in Jackson to be able to elect judges of their choice, and instead shifting that power to the state. I find, places like Kentucky and Wisconsin that are doing something even more nefarious than I think we've seen in the past, Rick, which is removing the power held by Democratic elected officials. And so we saw it first happening with so-called progressive prosecutors, where in Florida, Senator Rick Scott, who was then governor and now Governor DeSantis, removing power and authority from state elected prosecutors who he doesn't like and who consistently happen to be Black women. Although he also removed state authority from a white prosecutor, Andrew Warren, after the prosecutor indicated that he did not intend, if Florida were to pass such a law, to prosecute women seeking abortion. I find these efforts, they're happening also in Wisconsin. They happened in North Carolina with the transition of the new governor. And they are happening in Kentucky, where Republican-dominated supermajorities in the legislature are basically, if you elect a Democrat, then they take the power away from them. So it's heads you win, tails you lose, and this has the potential to make voting itself a nullity, because it won't matter whether you turn out and win the election. If you do, as a Democrat or progressive, they're simply going to take the power away from that elected official.
Yeah, I think that as an ex-Republican and as a guy who grew up in a conservative framework where supposedly the rule of law was the centerpiece of conservative philosophy, it's kind of astounding to watch these so-called conservatives run roughshod over the rule of law. I mean, Alabama just completely ignoring the district court. Ron DeSantis in Florida doing what he's doing. On all these cases, they lose and lose and lose on these cases, and they continue to proceed in absolute defiance of it. I mean, Stuart Stevens and I were talking the other day, and he wrote a book about, basically saying that race was really the underpinning of all this.
Always.
And called It Was All a Lie. It's a great read. But we were talking about this the other day, and in a lot of ways, they're going after voting rights stuff. The only echo of this in some ways that we can hope for is that it'll be like school integration. Eventually, the federal government will say, enough. You can't keep playing these games, and it's sort of a I hate thinking how thin that reed is in a lot of ways, though, because
I hate to say it, Rick, but I think that is the outcome they're hoping for. That in other words, they are modeling this on massive resistance to school integration, because yes, they were rebuked by federal courts. They were rebuked in Cooper versus Aaron, the Little Rock Nine
Yep.
case. They were rebuked in the Green case. They were rebuked in the Prince Edward County, Virginia case, where whites had closed the schools for 5 years rather than integrate. They were ultimately rebuked, but this gave them time to create a separate infrastructure, to create segregation academies,
Yes.
and it gave time for white flight to happen. And as we look at the level of segregation of our schools today, what we see is that that precious period that was lost during the all deliberate speed
Right.
actually had pretty devastating consequences. So I think they actually are precisely modeling on that because they see that as a win,
Yeah.
and not as a loss.
That should concern Americans at a pretty profound level, I think. One of the things I've been curious about at is the slow erosion of the Voting Rights Act at the federal level. What's the state of play on cases that are still trying to unwind, even though it's been diminished somewhat? What's the state of play on cases that are trying to unwind the Voting Rights Act?
Yeah. I mean, I think we are not out of the woods by any stretch of the imagination. We obviously have the Supreme Court having essentially decimated the most effective and powerful tool, which was Section 5,
Right.
which was, the preclearance requirement. If you think about it, Section 5, which required jurisdictions that had a history of engaging in voting discrimination to submit any voting changes for preclearance by a federal authority before they went into before they were enacted, was created precisely for the Alabama redistricting situation that we're dealing with right now, right? Where you have a
Right.
recalcitrant jurisdiction that will not, that they have violated Section 2, right? But, and the court has found it, it's gone all the way to the Supreme Court, and they don't care, right? And what's the result of that? The result, of course, is, as we know, when this case first went up to the Supreme Court, it ended up on the shadow docket, and the court just decided by an emergency order that it was too close to the election for them to enjoin the new map. The election was 9 months away, but that was still too close. And so in 2022, right, this is where there's national significance. And of course, this happened in Alabama and two other cases, one of which is headed to the Supreme Court this term, which is the South Carolina redistricting case. I believe Louisiana is as well. So you've got three cases, right, in which the court plays a vital role by using the shadow docket to refuse to make those changes. And the result is that for the 2022 midterms, you have a very different outcome in the House of Representatives than you might have had the court recognized that these defendants did not have a likelihood of success on the merits, which in Alabama, they ended up not being successful on the merits,
Right.
and had allowed districts to go forward that would have amply represented Black voters. And so there are national consequences to that as well. So the court is a player in this. The court weakened Section 2 in the Brnovich case 2 summers ago in a decision written by Justice Alito. So Section 2 holds on, but has been weakened as well. The Supreme Court's creation of that Purcell doctrine that I referenced just a moment ago, in which the court said, well, we don't make changes when it's too close to an election, but never told us how close is too close. We're now finding out that nearly a year before an election apparently is too close. So the court has been doing its role. And of course, John Roberts and Justice Alito, Chief Justice Roberts and Justice Alito have long been deeply skeptical about, if not hostile, to the Voting Rights Act. And so, there's no reason to be optimistic. We definitely dodged a huge bullet with the Milligan case this past term.
Right.
Maybe a reward for the court tearing down so many other precedents and protective statutes. But I don't think we're out of the woods by any stretch of the imagination.
Interesting. Well, so I want to switch tracks a little bit because you have been making some observations about the 14th Amendment and whether or not Donald Trump can be kept off the ballot in 2024. I'm not an attorney, but my gut tells me people should not invest too much in this belief because it strikes me as a long reach. He may be guilty of these things, maybe should be kept off the ballot, but I'm not sure we live in a world where we are that lucky. So, can you talk just a little bit about where the 14th Amendment comes into play here, and
Mhm.
whether you think that this is as whether you think people should be more cautious about this or less cautious about this in terms of its possible impact on 2024.
Yeah, I mean, I think there's two ways to think about this, Rick. One is about politics, and one is about law
Sure.
and democracy. And so let's hold on off on the politics, which is important and which I have a view about, but I want to talk first about law, because I do think that at this moment, Rick, where we are really in democratic crisis, it is incumbent upon us to do a bit of a forensic of how we got here, which I appreciate you and Stuart Stevens and other either ex-Republicans or at least never Trumpers have begun to do. But I think it's actually something the whole country has to do. And one of the things we have to recognize is that there has really been a failure to engage the tools that we have been given to protect our democracy.
Right.
And largely that's because we have not faced the kind of threat that Donald Trump presented, in that we did have a democracy that functioned with laws at their core, and you talked about the rule of law, but also with norms and ethics.
Sure.
And a set of unwritten rules and comedy. By comedy, I mean COMITY.
Yes.
Right. And those things were valuable and important. And what Donald Trump brought to the table, he did not create racism. He did not create voter suppression. He did not create political dysfunction. He did not create political division. But he certainly wrecked all of those soft tools that we relied on for the action of public officials and elected officials in particular. And it has pushed us back to rely more heavily on law. And I believe that we have to do that because we don't have elected officials who are guaranteed to behave in the ways and to respect the kinds of norms that had largely held our system in place without us even having to think about it. So that's number one.
Mm-hmm.
Number two, it has always been my belief that in this country, particularly in public life and in political life, there is a near erasure of the 14th Amendment, which I regard as being the most powerful and frankly most important provision of the Constitution for modern American life.
Right.
And this is, the 14th Amendment was one of the 3 Civil War amendments enacted after the close of the Civil War, the 13th ending slavery, the 15th it's essentially saying that you could not remove the right to vote based on race, color, or national origin. But the 14th Amendment being the core, articulating birthright citizenship, equal protection under laws, that phrase of equal, that equality, hearkening us all the way back to the Declaration of Independence,
Right.
which said that all men are created equal, including due process. And for the first time, recognizing and reorganizing the relationship between the federal and the state government, and expressing the reality that state governments could not be trusted when it came to certain kinds of conduct. And so you find language like "no state shall," right? Because
Right.
essentially the framers are saying, we've stared this down and it's a problem. And in that same, so that we all kind of know, even though we don't engage as passionately and conversantly as we should, the guarantees of the 14th Amendment. But what we absolutely never talk about are the provisions of the 14th Amendment that were designed to give us tools to protect our democracy against 2 kinds of threats that those framers had stared down in the face. One was the threat of insurrection,
Right.
and rebellion, and the other was the threat of white supremacist ideology. And there are 3 provisions in the 14th Amendment that speak directly to that. One of them is Section 2, which we could talk about another time, which imagines that Southern jurisdictions will still try to keep Black men from voting. At that time, women still had not received the constitutional right to vote, and creates a kind of regime by which representation will be reduced in those states that keep Black men from voting.
Sure.
Section 3 is the one that is meant to protect us against insurrectionists and those who are engaged in aid and comfort of insurrectionists who may try to undermine our democracy. That means, number one, those framers recognized that this was still a threat, or else they wouldn't have included it in the Constitution. It could have been in a statute.
Right.
And they wanted us to have the power. And what that section says, Rick, and I won't bother reading the whole thing, but it doesn't say anything about crimes or indictments. It says that that anyone who has engaged shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof.
Right.
Those people shall not serve in either federal or state office. So there's no criminal conviction required, no indictment required. And I think that this is an incredibly sound case. As a matter of fact, I think that Section 3 was created for precisely the white elephant. And by white elephant, I mean the unusual thing that we don't really face. I
Yes.
mean, this is not a slur on the weight of the former president, but it is about the thing that you don't encounter, which is what has happened to us,
Sure.
which is that we could not have predicted a Donald Trump, not that he would exist, but that he would curry the kind of favor and turn himself into a cult-like figure and
Right.
be as explicit as he has been about undermining American democracy. That is what it was created for. And so it is absolutely on point. Now, it would require, to go to the political point, judges to have the courage to recognize that they are faced with this constitutional provision. What is both, I think, intimidating but also exciting about it is it's not been often used, and certainly not at the level of the president. So, but why has it not been used? Because we have not faced at the level of the president someone who actually has tried to and participated with others in trying to overturn our democracy. So the fact that it's not been used, I'm sure, will frighten and intimidate some judges, but it hasn't been used for a good reason. It doesn't mean that, therefore, it is never to be used. It is a
Right.
tool that the framers of the 14th Amendment included so that we could protect ourselves against precisely this threat. Now, the politics, maybe you know the politics better than I, but my own view is that, the politics cannot drive this any more than indicting Donald Trump for alleged crimes should be driven by politics. There are people who said, don't prosecute Trump. It will only make him more popular. It will only make his followers more fervent. It only gives him an opportunity to play the victim. That may all be true. That doesn't change what the legal dynamic is and what is required by law. And I think our failure to apply that and to recognize that is our own step away from democracy. Once we have decided that this person is too dangerous for us to apply the law to him, we have become participants in the unraveling of our democracy ourselves.
I think that's it is. I think that's so on point. It is exactly I mean. Back in 2015, when I was still a Republican, I was warning my fellow Republicans, like, don't keep making exceptions to the rules for this
Yes.
guy. If you do it politically, it will metastasize. It will get worse and worse and more dangerous, and he will ask for more and more.
Yes.
My Southern grandmother used to say, if you keep throwing that alligator food off the dock, when you run out of food, it's going to eat you. And these guys, I don't think ever realized that the political lift they thought they would get out of him in the beginning transformed into fear of him.
Yes. Yes.
And now they're hesitant to follow the law, even though they secretly loathe and despise him, but they're afraid of even using the rule of law appropriately and constitutionally, because they're afraid of his followers killing them.
Yes.
I mean, that doesn't strike me as a healthy democracy.
Right. And what they say, it's like we've already lost then, right? And what they say is, let him lose at the ballot box. Right. We did that. He did lose at the ballot box, right?
Attacked the Capitol.
In the middle of a global pandemic with voter suppression and voter intimidation. I was leading the NAACP Legal Defense Fund at the time and leading some of, the most on the edge voting rights efforts. Sure. And what I saw in voter suppression and voter intimidation that year was extraordinary in the primary in particular and in the general. We saw people standing online for 9 hours to vote. We saw drive-bys at polling places with armed folks with Confederate flags. We saw the whole thing. We had to sue the post office to make sure that absentee ballots would be delivered, so on and so forth. And despite all of that, record numbers of voters came out and chose to rebuke Trumpism and to elect Joe Biden. And to put a fine point on it, they came back out a month and a half later in Georgia. 97% of the voters who came out for the general in November came out for the special in January, which is unheard of in a special election.
Absolutely.
Right? And they elected the first Black senator from the state since Reconstruction, and only the second statewide Jewish representative as a senator.
Mm-hmm.
So they handed the Senate to the Democrats and elected Joe Biden. That happened. When people say, oh, he should lose at the ballot box, he did lose at the ballot box. So that was January 5th, the special election. And then what happened a day later? January 6th.
January 6th.
So obviously the answer, sure, of course we have to get out and vote. We have to make sure that you're in the strongest position. But I can see nothing in what has happened over the last 5 years that suggests to us that we should lay down any tool, let alone a constitutional tool, in the fight to protect our democracy at this moment.
Right. I think I think it was a really good point to bifurcate the legal option and the political option. The political path is really hard.
Mm-hmm.
The legal path, though, is a path that we should be taking, even if it doesn't work politically. Yeah. I think you're right. I think we ought to push that as far as it can go, because if the anti-democracy side of the equation feels empowered all the time to push and push and push, and nothing happens to them, there's no legal or political sanction against them, then they'll keep pushing. They'll always try to, they'll keep crawling up the dock once you're out of. And
I'll tell you, don't be fooled by Donald Trump. The thing he does fear is law. He does.
Oh yes, Mary Trump told me very directly. She said his greatest terror is that he will go to prison.
Yeah. I mean, he's a serial lawbreaker, so that's what he fears. And so I just think, giving away our power is such a mistake, and can really be fatal. And when I say we and fatal, I mean to our democracy, and I mean to the we as people who want to live in a democracy. We are a flawed and catastrophically unhealthy democracy at this moment. But if we want to hold on to the remnant so that we can build the health of our democracy, then we have to be bold, and we have to be brave, and we have to use the tools that are available to us. And I, for one, am not going to lay down, and would not counsel people to lay down the tool that was created by the only framers who stared this kind of challenge in the face.
Exactly. And thank you so much for making that point on the 14th Amendment, because it was what I've been looking forward to asking you in a big way, because my political gut, I'm just too much of a realist and too burned out over the years to know on the political side how hard it is. But I think that was a really passionate and brilliant exposition of why we need to push forward on it. So
and just so so I'm moving to Howard Law School to take the Vernon Jordan Chair, as you pointed out, and I'm launching the 14th Amendment Center on Law and Democracy, precisely to refresh an engagement with the 14th Amendment, and to try to center it, in our discourse about who we are as a nation, and its values and its cautions, and to make us feel more comfortable with describing ourselves and moving forward as a democracy in a 14th Amendment context.
Well, Sherrilyn Ifill, I cannot thank you enough for joining us today on the Enemies List. What a great interview, and I am deeply appreciative of your time today. And we look forward to talking to you again very soon.
Thanks so much, Rick.
Thank you.